I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time. If I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly.
There have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised.
If the barrel length is less than 16 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
It is not a short-barreled shotgun or a short-barreled rifle, yes.
Either by barrel or by overall length?
Correct.
All right, and then count 6 is dismissed. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Count 6 is no longer part of your consideration. That was the firearm charge. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, I've got myself into a mid-sentence and I don't like it. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury and decided I better talk to you people beforehand.
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime.
I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on...
So, for example...
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told...
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
You're right. Tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here.
NBC News correspondent Shaq Brewster joins me now from Kenosha, Wisconsin. Shaq, let's take people back to the beginning of the day. The judge starting it off dismissing count 6. That was a misdemeanor gun charge against Kyle Rittenhouse. Could you tell us about that?
Yeah, it was a bit of a surprise, and the judge announced it in almost an understated way. It was count 5 that Kyle Rittenhouse was facing. It was the possession of a deadly weapon by a minor. And I'll tell you, going into this trial, it's an count that many experts said was the easiest for the state to be able to prove. It was a misdemeanor charge. It carried about 9 months in prison, and everyone knew that Kyle Rittenhouse was 17. It's very clear that he had a weapon. So people thought that bar to clear that count was going to be fairly simple. But you saw in that montage that you just played there, the judge dismissed it over essentially a technicality over the length of the weapon. That law is not easy to understand. It is a little bit complicated in the reading of it. And the judge sided with the defense in striking that or dismissing that count. So now Kyle Rittenhouse is facing those 4 felony counts.
Shaq, the prosecution also asking for lesser charges for the jury to consider. Could you walk us through that?
Yeah, and let's just go through all the counts that Kyle Rittenhouse is facing right now. Let's start with the first one, and I believe we have a graphic that we can play up right now, but it's that first-degree reckless homicide. It's a count that comes with that carries up to 60 years in prison. Then count number 2, that first-degree reckless endangering safety. There's 2 of those for 2 different people who essentially were shot at over the course of that interaction. Then you go to count 4, and that's the first-degree intentional homicide. In other states, this is essentially called first-degree murder. It's the count that carries a life sentence. And I think I said 4 before. Now we have the 5th felony count, and it's the attempted first-degree intentional homicide. For both of those last 2 counts, you not only have what was originally charged with was first-degree, however, but on the jury instructions, you also have an instruction that would allow them to convict on a second-degree count on those. So it gives the jury a little bit more flexibility to convict if they want. You hear the defense, and they've been making this claim all throughout the day. If their main defense is that Kyle Rittenhouse acted in self-defense. So they believe that if the jury accepts the idea that this was an action of self-defense, then none of those lower counts should even be considered. But that's going to be something that the jury gets to contemplate in about an hour here, Allison.
Shaq, Kyle Rittenhouse's mom spoke with NBC News correspondent Gabe Gutierrez. What did she say about her son's claim of self-defense, and what is she saying as she waits for this to go to a jury and then to get a verdict in her son's trial?
Yeah, Kyle Rittenhouse's mother, she's someone who has been in the courtroom, who has watched much of this trial, even getting emotional as she watched her son on the stand. She said that her son acted in self-defense and said that if he weren't armed that day, then she believes her son wouldn't be alive today. Listen to a little bit of that interview that she had with our colleague Gabe Gutierrez last night.
What do you say to people who look at this case and think this teenager had no business bringing a military-style weapon to this chaotic scene?
A lot of people shouldn't have been there, you know? And he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Do you think he would have needed to defend himself if he hadn't gone down there in the first place?
You know, if he went down there to help and he was chased by a mob.
Now, that question that you heard her answering, that Gabe asked, it was the idea that the prosecution has been painting all throughout the closing arguments, especially, and even going back throughout the trial, the idea that they say Kyle Rittenhouse came here looking for trouble, came to Kenosha with that weapon, looking for trouble, and found trouble, and then found himself in a situation where he needed to defend himself. So that is the idea that you hear from the prosecution. Again, the defense saying that this is about self-defense, and this is something that is going to be watched very closely and a big decision that the jury will have to make when they begin deliberating, Allison.
So, Shaq, I said off the top here for our viewers that we're in a little bit of a break now. For folks who are just joining us, could you sort of set the scene where we are in this case right now and what's to come next?
Yeah, so the latest that we just heard from the defense. We heard them give their closing argument. Right before then, we heard the prosecution give that closing argument. So there may be a rebuttal that we have coming up, but we are very close to this being handed off to the jury and for them to be able to decide. And we started the day, as you mentioned, going through those jury instructions. It's about 32 pages of pretty dense material that goes through the law that tells the jury how they should apply the law, what the law says, and kind of connects it to what this case is, or what the prosecution is arguing in their case. So all of that is going to be decided by the jury. One thing that we saw earlier today, and this goes to your question of timing, the judge asked, he polled the jury, if we got to a position that we're essentially in right now, where both sides have wrapped up their arguments around 5 p.m., would the jury want to go straight into deliberations, or would they want to end the night and come back tomorrow and begin their deliberations starting out fresh? The jury was split in what they wanted to do with that, so the judge kind of shrugged it off and said he'll decide and he'll make his decision a little bit later. We're close to learning what that decision will be, and that will determine whether or not they begin deliberations, which means we'll be on verdict watch tonight, or if they'll wait until tomorrow when there's a brand new day and when they come back in, and that can be the first and only thing that they do.
All right, we'll have to wait and see how that goes tonight. Shaq, before I let you go, I know the National Guard was called in on standby. Could you just describe what it's been like outside the courthouse throughout the day and this evening?
Yeah, there's been a growing crowd at the courthouse, in front of the courthouse. It's still relatively small. It's nothing like we saw, and you've been watching the trial, nothing like the images that we saw back in last August after the shooting of Jacob Blake. But there are a vocal group of folks outside of the courthouse. One of the pool notes actually mentioned that at one point the crowd outside, again, a handful of people, or more than a handful, maybe about a dozen or two. But at one point, the crowd outside could be heard inside the courtroom. It wasn't clear whether or not the jury heard the crowd, but at one point you could hear the noise, according to the pool reports there. But you mentioned the National Guard. The governor did activate the National Guard, about 500 members of the National Guard. But the key word there is activated. They're not fully deployed. They're not mobilized. You do not drive around Kenosha and see those military vehicles. Instead, they're ready to be, they're standing by, ready to be deployed if that order comes in from local officials. As far as we know, that order has not come, and there's no reason to believe that order will come based on what we're seeing right now, Allison.
All right, Shaq Brewster in Kenosha, Wisconsin, where we should find out tonight when the Kyle Rittenhouse case will be handed over to the jury. Shaq, thank you so very much for reporting tonight.
You got it.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.